Good afternoon. Welcome to the Appellate Court. The first matter is Nonhuman Rights v. Commerford. And counsel, you have 20 minutes for your argument if you need to use that time.
Thank you, Your Honor. I'm Stephen Wise, Your Honor. May it please the court. I represent, well, when the case started, 3 elephants, Minnie, Beulah, and Karen. 2 of them have died since we began the case. So right now, the only living client we have left is Minnie.
When did Karen die?
Karen died, we believe, in March of 2019.
And when was the prior appellate court argument?
April in 2019.
Was the appellate court advised that Karen had died?
We did not know that at that time.
You didn't know that your client had died?
No, we did not have access to her. We don't have access to any of our clients. We just happened to learn by happenstance that she had died, and then it was our client Beulah basically died in public at the Big E Fair in Springfield, and that was in September, and that's when we learned that she was dead.
Now, Minnie, you had filed a motion for an injunction with this court because of the possibility of Minnie being moved to Florida. Is that correct?
Minnie moving somewhere, we aren't certain, but that is correct, Your Honor.
Is Minnie currently in the state of Connecticut?
We believe that Minnie is in the state of Connecticut. We have no reason for thinking that she's not.
Okay.
But the appellee doesn't speak with us, so we don't really know. We suspect, though, because of the press involved, that it's not easy to move an elephant when no one knows out of Connecticut into anywhere else. So we were concerned that this court could lose subject matter jurisdiction if she left the jurisdiction. Yes, thank you. So first, I'd like to argue that the lower court in this case erred in dismissing the petition as an improper success petition because there was no res judicata, because there was no full and fair hearing, and also.
Before we get to the arguments about what the lower court did, we do have this court's prior decision.
Yes.
Which said that you lack standing because. Well, now Minnie doesn't have standing of her own to assert the claim.
Yes, Your Honor.
Don't we have to address that issue?
I'll do that right now.
Okay, so
yes.
let me ask you about that, because you filed a supplemental brief.
Yes, Your Honor.
And it seemed to me from reading your supplemental brief that what you're asking this panel to do is overrule the prior panel. Is that correct?
Well, we're asking this court to assemble an en banc panel under Practice Book 70-7B, because as I understand it, that's the only way that case can be overruled.
That's true. But you asked us to consider, you filed a motion for reconsideration en banc after the last panel issued its decision. Correct?
Yes, Your Honor.
And that was denied.
Yes, it was.
And then you filed a petition for certification to the Supreme Court, which was denied.
That's right.
And all of the issues, it appears to me that all of the issues that you are raising in your supplemental memorandum regarding what you perceive as errors in the first panel's decision were raised in your petition for certification and in your motion for reconsideration en banc. Is that fair?
It is not.
Okay, so
no,
what is different?
No, it is not fair.
Okay, so what's different?
Okay, so the most important, there's actually 10 issues that I wanted to raise. If I can get to all 10 of them.
All 10 of them are different?
Yes, there are 10 different issues.
10 new issues.
I don't know I don't know how many are new issues, how many are not new issues.
Well,
but let me start with the.
Well, since we've denied your motion for reconsideration en banc, we should just be hearing the new issues.
Well, I think the major issue, or at least the one I want to start with, is the fact that the lower court, or I'm sorry,
Go ahead.
The appellate court conflated standing with the merits, and in Connecticut, you're not allowed to conflate standing with the merits.
But you raised that issue in your petition for certification, and you raised it in your motion for reconsideration en banc.
Yes, but the problem is that the lower court, I'll refer to as Commerford 1, and this is Commerford 2. What the other court did was find that we didn't have standing because we lost on the merits. The problem that we have had is that we've never had a hearing on the merits.
And so let's take that as a given, that you haven't had a hearing on the merits. This court decided in Commerford 1 that you were not entitled to a hearing on the merits because you lacked standing. And then you raised as a reason why that was wrong, both in this court on your petition, rehearing en banc, and in the Supreme Court in your pet cert, that the first panel conflated the merits and standing. And that argument gained no traction either with this court en banc or with the Supreme Court.
Well, perhaps I'm thinking that if I have a chance, and this is the first chance I've ever had to actually discuss the issue, because it's never been it was never raised in any trial court. It was never raised in the appellate court. We've never actually been able to discuss and have the opportunity of persuading you that this is not permissible under Connecticut law.
And did you file a request to have this case heard en banc?
I do not believe that we have filed a request to have it heard en banc.
So then how can we do anything?
Well,
you acknowledge that we can only, an en banc panel of this court can reverse a panel. But you haven't asked this court to hear this appeal en banc.
well,
So are you
under-
waiting for the three of us to say we can't reverse a prior panel, then you'll file a motion for reconsideration en banc?
Well, as I understand it, under Practice Book 70-7B, we are exactly allowed to do that. As opposed to, I believe, A, in which we can ask previously, or B, in which we can ask subsequent to oral argument.
So it seems to me that what you're saying to us is the three of us are kind of wasting our time here today because you know that we have to follow the other panel, and then you'll file a motion for reconsideration en banc and hopefully get all 9 of us out here.
Yes, Your Honor, that's exactly what we're hoping to do. I gather that you don't agree that that was the
Well, I
correct
think-
procedure.
No, I think the right way to do it would have been to say that we think that the first panel was incorrect and we know you can't overrule another panel, so therefore this should be heard en banc. And then we could have decided whether to hear it en banc. But go ahead.
That's all I can do today, is to argue it, and then we'll file a motion, and I will hope that I'm persuasive enough so that at least the three of you would agree that it should be heard en banc. That's how I understood it.
Well, first of all, Judge Beach doesn't get a
two.
chance to vote on whether it should be
Two
heard en
of
banc,
you.
but-
That's all I can do, Your Honor.
Go
and
ahead.
that's what I'll do.
Yep.
Okay, so it does conflate standing. Cannot be conflated with the merits, and the problem is because not only was standing conflated with the merits, but perhaps even more egregiously, it's that we've never had a chance to argue the merits because we had no idea that the merits was going to be at issue. In the first case that we filed, we lost based upon standing, claiming that we had not alleged a significant relationship with the elephants. When we appeared in Commerford 1, at that time, we had briefed only the issue of third-party standing. We had no idea that the merits were involved. We had no idea that the merits were involved at oral argument, and we did not know that the merits were going to be involved until we lost on the fact that we lost standing because we lost on the merits. Well, it seems that there's a fundamental fairness problem here in that while the Commerford 1 court said, well, we're going to affirm the lower court on the grounds of standing, we're going to make I think they used the word there's a slight difference in the grounds. Well, moving from the fact that we don't allege a significant relationship to you lose on the merits, that's not a small problem. That is the problem. I mean, there are fundamental fairness issues in that we've never been able to argue the merits. And when we filed the Commerford 2 case in the Superior Court, we were then dismissed, or the court refused to issue the writ of habeas corpus, on the grounds that it was supposed to be an improper successive petition, which I'm ready to argue it was not. We didn't argue the merits here. We've never argued the merits, and we're not clear that any of the judges before whom we have appeared even understand what the merits are.
Why was Commerford 2 filed in the Judicial District of Toms?
We had believed that the judges there would be able to have a greater understanding of habeas corpus. We felt that the first judge...
So it was judge shopping?
We were judge shopping, Your Honor, yes. Habeas corpus is, yes, we were judge shopping. We weren't trying to find a judge who was going to rule in our favor.
For a second. Attorney Schellenberg, can I ask you a question? Could you please stand up at the microphone?
Oh.
Yes.
Were you fully cognizant of the judge shopping going on in this case?
I personally was not involved in the matter before the trial court, Your Honor.
Okay.
So no.
All right. Okay, thank you.
Judge, I think judge shopping is when you're looking for someone who's going to rule in your favor. We're simply looking for someone who worked in the area of habeas corpus day in and day out. That's the only reason we went there. We had no idea whether they're favoring us or not favoring us. We wanted to have an argument on the merits about habeas corpus with judges who are familiar with it. They didn't have any truck with that. They just sent us back to the first to the same county, and that's where we stayed, and that's where we were dismissed on the grounds that it was an improper successive petition. So the second thing I want to argue, other than that, after this serious problem that we've never argued the merits because there's a conflation of standing with the merits.
Just to let you know, because the clock isn't working that well, you have...
I have no idea how much...
You have 5 more minutes.
Oh, okay. Well, is that Minnie is already a person under the so-called pet trust statute. Minnie was, has the rights of a trust beneficiary under the pet trust statute, and she even has a trust protector under the pet trust statute that will indeed protect her rights. The Commerford 1 case said that a non-human animal can't be a person. But the legislature has already made non-human animals in Connecticut a person. And a person simply means that that's an entity who has the capacity for rights. So Minnie has always been a person for the last 10 years. And the right that she had was the right she gets as a trust beneficiary. What we're asking for was a second right, which is the right to bodily liberty protected by a common law writ of habeas corpus. So for the Commerford 1 court to say that we can't, that our client doesn't have standing because she's not a person, well, she is a person. She's been a person for at least 10 years under the pet trust statute. Once you're a person, it doesn't mean you have all the rights of a human being. It simply means that you are a container for rights. You have the capacity for rights. So she has had that capacity, and she, as well as every other animal, non-human animal, has had the right of a trust beneficiary. In fact, we have set up a trust for her, and she indeed has the right to that trust and has a trust protector. The third thing is that the Commerford 1 decision that somehow social contract prevented our non-human animals from having rights. The quotation that Commerford 1 said within its own decision undermined what it said. It correctly quoted Moore versus Ganem, saying that the social compact theory posits that all individuals are born with certain rights. Well, once you're born with certain rights, you have to be a person. By definition, a rights bearer is a person. So under social compact theory, this court in Commerford 1 itself stated that it involves entities who are born with rights. If you're born with rights, you're a person. So you cannot not be a person under social compact, and that's because we didn't get a chance to argue any of this, and that's because the Commerford 1 court misunderstood what social compact theory was and thought that it had something to do with the creation of persons. It doesn't. It has to do with creating citizens from entities who are already persons. And in our appeal, the only high court judge in the United States who's ever discussed this is Judge Fahey in the Lavery case, and he criticized that. He agrees that is not so. Also, the fact that the court concluded that to have third-party standing depends upon Minnie already having standing. This conflicts with a decision of the Connecticut Supreme Court that actually binds this court, but though Commerford 1 did not feel bound for some reason by it. And that is the famous case of Jackson versus Bullock, where you had a freed slave, you had a free slave, James Mars, who learned that a slave, Nancy Jackson, who was in Connecticut, was about to be sent back to the South. He then, who was a stranger to Nancy Jackson, then went into court and sought a writ of habeas corpus on.
Now, you argued this particular issue in Commerford 1.
Well, we never argued it because
Well, you did argue it because the FTR from that hearing shows you arguing the exact same argument you're making now, and it's also in your petition for certification to the Supreme Court.
Well, there's an argument that we can make on paper, but then there's an argument that we want to make in person, and if possible, have a dialogue with the court as to what the meaning of it is.
You did have that dialogue with the panel in Commerford 1. I heard it.
It wasn't exactly what I'm about to say, but I did mention Jackson versus Bullock, and if I did have the dialogue, then for some reason my argument is that Commerford 1 misunderstood completely what the Jackson versus Bullock case is, because Commerford 1 is completely inconsistent with the Jackson versus Bullock case, and Commerford 1 is consistent with a Supreme Court of Connecticut case that binds it, yet it does not pay any attention to it. You can't have both Jackson versus Bullock and Commerford 1. They are inconsistent with each other. You can't have someone who is not the Commerford 1 case says that in Jackson's, that Nancy Jackson had to have been a person. But Nancy Jackson wasn't a person. Nancy Jackson was a slave, and Jackson versus Bullock itself said that under the social compact part of the Connecticut Constitution, that a slave was not part of the social compact. So you had James Mars, who's the equivalent of the Nonhuman Rights Project, argue on behalf of Nancy Jackson, who's a slave, who is the legal equivalent in that they're not a person, they don't have standing, of Minnie. And in Jackson versus Bullock, you were allowed to do that. And indeed, that's how common law works in every. Is that me?
Finish your argument.
Okay, that's how it works in every single English-speaking jurisdiction throughout the world for the last 400 years. And Commerford 1 stands out as an extreme outlier with respect to a private detention. There's never been a case like Commerford 1 in any English-speaking common law jurisdiction ever. The closest that it comes to is the Whitmore case, which had a suggestion that you had to have some kind of a significant relationship. But the problem is, and Commerford 1 also made the mistake of saying, citing the Johnson versus the Commission of Correction case, made the mistake of saying that Connecticut follows the law of English common law and of the federal statutes. Well, that only happens in the case of a public detention. The United States courts do not have jurisdiction over private detentions, and anything they say in the Whitmore case, under, I believe it's 42, section 2241, it's only about public detentions. Plus, Commerford 1, plus the federal statute, and the federal courts are dealing with an Article 3 limitation that the Connecticut courts are. And that led to Commerford 1 making a whole series of clear errors, not just one, not just two, and there's a cascade of errors, and we believe that the reason that occurred was there never was the kind of dialogue that I came here today hoping to engage with the court to try to show, one by one, that there's an error. For example, they also said that
I've given you a very fulsome 20 minutes, so just
am I
summarize, and we'll of course read the record in the.
I'm sorry, Your Honor, I couldn't.
Just summarize. You've exhausted your 20 minutes. Would you like to say anything in
I'd like to say a lot more, Your Honor, but
In
I
summary.
understand since we focused on Commerford 1, Commerford 1 is riddled with errors. Commerford 1 is a singular outlier in the common law world. In 400 years, there's never been a case like that anywhere in a common law jurisdiction, and that we will, if we do not prevail here, we will then accordingly seek en banc review. And all I can do is urge this court to consider that I may be correct, and if I am correct, I hope that either we will reassemble or for an en banc hearing, or that other judges will listen, or whatever they do in order to be able to decide whether we should have an en banc hearing. But if we do,
Okay,
it'll be the
Attorney
first
Wise, thank
time
you.
we ever argued on the merits.
Thank you, Attorney
Thank you, Your
Wise,
Honor.
Attorney Schellenberg. We've concluded the first appeal argument.